right. This is the Jurisdictionary lawsuit flowchart. Lots of people are talking about it because it is probably the simplest presentation that gives you the big picture of what a lawsuit is all about. And of course, it begins with the complaint. The complaint is a pleading. We call pleadings pleadings, motions are motions, other things are other things, and you will learn what we mean by pleading. Complaint is a pleading in that it pleads or states the plaintiff's allegations and demands a judgment. In the course, we go into great detail and give samples of complaints and so forth and so on. But in its essence, the complaint tells the court what the plaintiff alleges, what the plaintiff wants, and why the plaintiff should get what he wants. Now, after the complaint is filed, it is served on the defendant with a summons. Actually, a copy of the complaint gets served on the defendant with a summons, and the copy of the complaint. The original complaint stays in the clerk's file. Once the defendant receives the summons and a copy of the complaint, he has a certain period of time to answer the complaint or file one or more of what we call the flurry of motions. He can file a motion to strike, a motion to dismiss, or a motion for more definite statement. There are only those three. And if he succeeds with one of those motions, he won't have to file an answer at all. He would file one or more of those motions. The court would eventually rule on the motions, possibly after a hearing. And if the court rules favorably on one of those motions, then the case is over. Or possibly the plaintiff is required to refile his complaint, depending on what the situation's all about. And of course, the course goes into greater detail. If the flurry of motions fails, then the defendant must file an answer. And if he files an answer, he should also always file as many affirmative defenses as he has. And again, all of this is explained fully with examples and forms and everything in the complete course. The answer responds to each allegation of the plaintiff's complaint and then states the defendant's allegations of fact and law in defense. And then the defendant demands judgment in his favor. At each stage, both parties have access to what we call discovery. And the discovery is done with one of 5 different tools: the request for admissions, request for production, interrogatories, depositions, or subpoenas, under which category we include court orders, such as a court order to have a deputy sheriff go out to a warehouse and break the lock and let one or the other party go inside the warehouse. But that all falls under the heading of subpoenas or court orders. So you have requests for admissions, requests for production, interrogatories, depositions, and subpoenas. And as the 3 arrows show, these are all available before trial. The plaintiff and defendant both use their 5 discovery tools at all times prior to trial to get at evidence that will tend to prove their own allegations and undermine those of their opponent. The key to winning is knowing how to use your 5 discovery tools effectively. Now, after the discovery period closes, there's no further opportunity to use any of these 5 tools. The case is set for trial. If one of the parties didn't win before trial, using one of the methods that's also set out in the course. Trial is a formal setting for both sides to present their evidence and legal argument. It is not like you see on TV, where you would get the idea that it's all about the trial. Most of the work, indeed probably 90 to 95% of the work of winning a case, takes place before trial. And if you do what we teach in this course, you shouldn't go to trial. You shouldn't have to go to trial if you had a winnable case in the first place, because by filing proper pleadings, whether it's the plaintiff's complaint or the defendant's answer and affirmative defenses, and using your 5 discovery tools skillfully, if you have a winnable case, you should be able to prove that before trial. Winning in court is easy once you understand these simple steps in the process and how to use each step effectively. That's what the course is going to teach you. Many lawyers never learn what this simple diagram shows. By learning how to use each step effectively, you control the outcome. If the law and facts are on your side, and you know how to get your evidence into the record and how to cite and argue the law, you win. So, that's it. That's the lawsuit flowchart. We'll go over this again later in the course.